Should terrorism suspects be tried in U.S. federal courts or in military commissions? That question is debated here by former chief prosecutor for military commissions at Guantanamo Bay, Morris Davis, ACLU Executive Director Anthony Romero, and attorney Joshua Dratel, who's defended terrorism suspects in military courts. Hosted by New York University Center for Law and Security, this is just under 90 minutes.
All right, so we're going to begin. My name is Karen Greenberg. I'm the Executive Director of the Center on Law and Security here at NYU Law School. Almost all of you we've seen before, so welcome back. Most of you know this is probably maybe our 30th discussion of trying terrorists in civilian courts or in military courts. Unfortunately, I think it may be our last such discussion. And so that's the note on which I begin. We'll give you a very brief overview of the context of today's discussion and then turn it over to our panelists. As always, tonight will end at 7:30. We will leave as much time as I can, given our loquacious speakers, for discussion, but I will begin the discussion with my own questions. As you know, the reason we've had so many of these panels is that the discussion of how to try terrorists that we apprehended off of American soil began with the invasion of Afghanistan, the U.S. invasion of Afghanistan in the fall of 2001. President Bush issued a military order, later renamed an executive order, in which he stated that those matters of detention and trial would be turned over to the Department of Defense for the foreseeable future, or for the war on terror. There are many details of it that I won't go into, but one thing that Eric Holder did when he announced that Khalid Sheikh Mohammed and others would be coming to trial in Manhattan was to make it very clear that the Obama administration wanted to redress what had happened during the Bush administration, which was basically taking many of the powers that could have been placed in the Department of Justice and giving them to the Department of Defense. And it was not insignificant that he picked the same day to announce Khalid Sheikh Mohammed's move to New York, or his intended move to New York. It was the same day that Bush had issued his military order in 2001. However, as a surprise perhaps to me and maybe others of you, that wasn't the end of the story. And what has ensued since November of last year and today is a very long, attenuated discussion about whether or not the United States can or should try Khalid Sheikh Mohammed and other of what are termed the high-value detainees currently held at Guantanamo Bay, should try them in federal courts, in civilian courts. There are many politics that surround this, and we will get to some of that today. There are many legal issues that are complicated, many that are still unknown, and we will talk about that today. But I think that this decision is going to be made rather clearly and rather definitively in the very near future. So I thought today the purpose of this is not, to come out with a let's do it one way or another. As you know, the Center on Law and Security has spent years working on the Terrorist Trial Report Card. We have examined nearly 1,000 trials that have taken place in this country that have tried not people apprehended abroad necessarily, but people apprehended here. But they have tested the courts in terms of terrorism, and not only that, they have created a profession. And so I thought we would really like to hear this vetted, not just from the point of view of advocacy of the federal courts, but what actually the military commissions could offer of us. There have been a number of military commissions acts, and our speakers can go through them. There is one that is currently, it would be in effect if we brought Khalid Sheikh Mohammed and others to trial under military commissions. It is a new act, and as a result, I'm not sure of all the details of it, but I will certainly push our panelists to tell us something about it. So what I'm really trying to say is that I'm hoping, and I say this to my speakers, this will be an open discussion, and with the open mind that what are the possibilities for trying these people? What is it we're trying to accomplish other than conviction? How much of this is about things that are really separate from these criminals or enemy combatants or whatever it is we want to call them these days? and how should we be thinking about this that maybe we're not thinking about that. So without further ado, I'm going to introduce our panel very briefly. You have their bios, and then I will ask them to talk. To my far right is Anthony Romero. Anthony Romero is a good friend of the center and one of my personal heroes. Because he has one of the hardest jobs in America, I think. I don't know how they do everything they do. He is the head of the ACLU, and he is responsible for all of the things that you read about in the papers that you both agree with and disagree with, depending on what day and topic it is. But Anthony is somebody who understands the politics of these issues and does not just advocate for his causes without thinking very carefully about who's going to hear it and what kind of compromises can be made and may be made for some kind of pragmatic end. And that's why I've asked him to join us tonight. Closer to me is, in every way, is Joshua Dratel, who, as you know, is my co-editor on two compendiums that we've done here at the center. He is one of our newest fellows. He is the person who's getting the most flack for our new blog, and I think you're going to enjoy hearing from him. On my left is somebody new to the center, Morris Davis, who I'm sure you know more colloquially as Mo Davis, who was the prosecuting prosecutor, the chief prosecutor at Guantanamo, really for pivotal years in which this discussion was going forward about who we were trying at Guantanamo, how we were trying them. He was involved in charging all three of the individuals who were later convicted at Guantanamo, and he was there for the conviction of David Hicks, who, by the way, was Joshua's client. So, and he has a rather interesting perspective because, and I will let him tell you this in his own words, he is no longer prosecutor, and I will let him tell you how that came about. And I actually think that he and I have talked prior to this. He's written on the topic of military commissions, of military courts martials, of the civilian courts, and I think that he adds a perspective that is not necessarily antagonistic, because that's not how this conversation I think is going to happen tonight, although it may, but is actually just he has a different take on how we might go forward, and so I thought it would be interesting to hear from him as well, and then we will hear from you. So we're going to start tonight with Joshua, who will tell us a little about the lay of the land as it stands now, and why we may or may not want to proceed towards military commissions.